there is something called hierarchy of courts in the Nigerian legal system. So what that means automatically is that when there is a case pending before an appellate court, that is a higher court, every other court that is lower than that court needs to stay proceedings. They need to wait and first of all listen to what is happening, what's going to happen at the higher court. And once that happens, then the lower courts can now decide or can now be given rights to pursue the matter. So for instance, there's something called preliminary orders. There's something called locus standi. There are a lot of other preliminary objections that can happen in a civil or in a suit. And sometimes when those preliminary objections are raised, a judge can decide to strike out or to take a decision or make a ruling in that instance. And when a judge makes such rulings, if those rulings are not agreeable by parties, they can now go to superior courts to then seek an appeal. So what has happened is that in this instance, ADC, Accord Party have decided that they were going to appeal some of the orders that has been granted by the Federal High Court, before the Court of Appeal. That automatically means that the Federal High Court is supposed to stay proceedings. And it's not just as a rule in this instance. It is a fact that the Court of Appeal, in allowing for that appeal to take place, gave an enrollment order that also instructed the Federal High Court, the lower court, to stay proceedings, clearly written in the enrollment order, which therefore means that no court of jurisdiction should entertain any of those matters at the lower level until the determination of the case that is pending at the Court of Appeal, at the appellate court. So for Justice Lifu to decide on his own to sit down and hear the matter while the Court of Appeal is supposed to sit down and hear the matter in October, is actually what people call judicial rascality, and I tend to agree with that, because you're supposed to listen to what happens at the Court of Appeal for you to now decide whether, when the case comes back to the court, to the Federal High Court, for you to now decide on the merits of the matter and then handle the case. So for us, we believe strongly that he had no right, to listen to or to attend to the matter at all until the Court of Appeal had decided what is happening. It's just like what is also happening in ADC, for example, where the David Mark-led committee, National Leadership or Committee, has gone to the Supreme Court to seek clarifications of what has happened in the Federal High Court, and including the Court of Appeal. And then you now say that a High Court of Abuja, Maitama Division can now decide to sit on that. That is very wrong and is an abuse of court processes.